Okay, and this week I want to go over some of your discussion board posts to help you further understand the concept of sovereignty and why it's so important as you try to make sense of the balance between individual rights and group rights against the desire or the need for social control. And you really want to think about this in the context of how judges in the Supreme Court interpret legal issues. So this is kind of a baseline or a really important foundational concept that'll help you understand other concepts. And so you'll see that people have a lot of different opinions as to the principles that should be involved in deciding what sovereignty is. And this really comes out in the three different judges that you read. And so Justice Iredell really viewed states as the ultimate form of the representative government, as being sovereign, but that they should also be subject to the sovereignty of the federal Congress, and that they did this by consent by joining in the Union under the United States Constitution. So again, he's looking at state representatives. So people who represent us through elections, those are the ones who are the sovereign, but they also have to be limited by these sovereigns in Congress, who were also elected by members of the state. Justice Wilson, on the other hand, goes for a much more historical point of view, which is that the individual has always been sovereign, that your ultimate freedom lies with you, and that must be protected against the abuses of state representatives. And so he wants to make that clear in his writing that the individual is sovereign, but that the sovereign individual can give away at least part of their sovereignty to representatives of the states, but that doesn't mean that they can be abused by those representatives. And then Justice Jay was a lot more abstract, really, made it a little bit more complicated by saying, well, it's not the states that have sovereignty and it's not the people that have sovereignty, it's this compact, it's this written law that we have. That's really actually the sovereign. And so you'll hear, this is a nation of laws that Justice Marshall says in a different case. This is what he's talking about, this kind of view. This is also Marshall, Jay, Alexander Hamilton, and James Madison were known as the Federalists, and this was their concept, was that this written document, this compact that the representatives of the states were entering into, that was actually the sovereign document. So it wasn't a person, it was a piece of paper. And so he justified this by saying this was a process, right? The citizens of the colonies then turned into states. They get to govern themselves, and that's what they had been doing before the Constitution was drafted. And so then they set up a system in which they'd do the same thing with each other. Each of the states would govern themselves, but they would also submit to each other's government. And this was his idea here, is that, again, it's not the representatives of the state, it's not the individual, it's a document, it's a compact that people had made. And you should really think of that as a process. So we want to put this in context. This is very early in the United States history, right after the Declaration of Independence, the signing of the Constitution, and also of the war against Great Britain. And so we want to put that in context to understand that the country is not really developed, right? They haven't really come to habits or experience of self-government. They're right in the very beginning of it. And so right before this, they were all the king was sovereign of England. And so, they didn't, it's not that they weren't thinking about these kind of things, but the history had been that, you don't question it. The king is the sovereign. And so only a few people were writing about, philosophers were saying, well, maybe the individual should be sovereign. Others were starting to say, maybe we should have elected government, maybe parliament in England should be more powerful. But by and large, everyday people like you and I, we just understood the king is sovereign. That's the person who makes the choices, and so we have a duty. We have to comply to the king's demands because we're the subjects of the king. With the Declaration of Independence, the Articles of Confederation, and the representatives of the colonial governments, they now were sovereign, right? They essentially stole sovereignty from the king, and now they had it, and so they got to make up their own rules. And this is really where you start to see them really wrestling. They're debating. They're trying to figure out, well, if every person is sovereign, then they can do whatever they want, right? And that included taking other human beings as slaves. It could be punishing people, throwing them in private jails. There's all sorts of things you could do. You could take property from people. And so then they said, well, the state has to be there, that the colonial government has to be sovereign in issues of property. So they have to be able to say, no, you can't take this form of property, or if you do take this person as your property, these are the circumstances under which you can do it, how long they can be a slave, etc., etc. But there's no real enforcement mechanism here, so compliance is no longer an obligation, it's a moral decision. So if you're a good person and you agree with the government, then you're going to go along with these rules. But there's not really anything, forcing you to do that. You now see a much shakier or a looser version of sovereignty. Now, another thing to think about is that when they say the people, when the judges are talking about the people, they're not talking about you. They're not talking about people who are slaves. They're not talking about women. They're not talking about children. They're not talking about poor people. They're not talking about immigrants. They're actually not talking about Catholics. They're not talking about Jewish people. They're not talking about, I'm trying to think of who else they're not talking. They're not talking about people who are indentured servants. They're not talking about apprentices. They're not talking about people without land. So they're largely talking about English white men who own property. And so that's what they mean by the people in those legal opinions. They also were thinking about the federal court being the place where they have to try to make these decisions about who's going to be sovereign in particular situations. So in this one, it was about whether an individual can sue a state, and which of those two things is sovereign, and then is the federal government sovereign. So they're trying to understand how should we be thinking about sovereignty. Over time, you start to see this be the people tends to be the majority of those white men, the majority of those elected landowning English men. And so this is then you have a minority, right? You have people who disagree with this position, and this is where you start to get Republican Democratic politics. And so now compliance is not even really moral, because your morals are tied to your party, right? So if you're in the majority, it's moral to follow the majority code. But if you're in the minority, it would be moral to follow the minority code. So now you kind of see sovereignty shifting to these political parties. And so we have on the court right now, the bottom picture, 6 of the present Supreme Court justices, so 6 out of 9, that's a majority, are what are called originalists. So they interpret the meaning of the words of the Constitution to ask, well, what did the original writers think? So again, the definition of the people are not minorities, they're not poor people, they're voting, and really actually the representatives, as representatives of those voters, are the people, right? So the people who are elected to Congress, the people who are elected to state legislatures, that's who they mean by people. And so at the time of the Constitution, those were wealthy landowning white English men. It's not too different today, right? There are more minority representation, but it's still largely wealthy white men. And so they're kind of staying with this idea. And you see this in Scott versus Sanford. You'll read that case later, where they go ahead and tell you, the Supreme Court says why they think this is the right definition of the people, why this is who they think should be citizens. Now you have to understand that the Civil War follows that, and changes are occurring, right? But that goes back to that majority-minority push and pull, that tension between those two social groups. And so you want to think about just, this present court having this kind of very narrow idea of who's sovereign. So the sovereignty would be that Justice Iredell concept. It's the people who are the representatives in government. That's who they mean by the people. They don't mean you, they don't mean me. Now this is very different than your answers, right? Your answers tended to look at the people as us, right, as individuals, having more say in government. and having more say over everyday issues. And so I have to wonder, right, as opposed to the originalists, there's another theory of interpretation called living constitutionalists. And so you'd ask yourself as you go through this class, do you want the principles of the Constitution to be updated with modern times? If so, you'd be a living constitutionalist. Do you want more political participation, that you get involved in running for office, that you think there should be more diversity, that you should think more diverse people should be engaged in powerful positions? If so, you're a living constitutionalist. Are you less interested in political representation? Are you more interested in direct democracy, in something that would be different than this electoral system? Then you might be beyond a living constitutionalist. You might be moving towards some other way of thinking about constitutional politics, or even a different system. The other thing to think about is about half of the students completed this assignment, and that's about accurate. That's about half of the people in the country participate in elections and or are elected representatives. And so you'll see, individual sovereignty is a lovely idea, right? It's the complex but right path. It's the one where you be in charge of your life. But you can see the majority of people really like the simple but wrong path. And so that's a big, complicated issue in this sociology of constitutional law. We have to look at, well, how do social groups actually behave, right? Not what's written down. So Justice Jay had a lovely principle. It's very ideal about the Constitution being a document that everybody's going to follow and agree with, but it's not reality. It's not what actually happens. And so we want to think about that. And then this is a word cloud from the most common nouns that you used in your answers. And so you'll see again, sovereignty and the people, you really were putting those two things together, but it's not really clear to me what you mean. So in the assignment, you're going to go into more detail about what do you think about that concept of people. And then see that country, right? Country was actually more often used than states. So many of you tend to see people as Americans, not New Yorkers, right? Which is also very abstract, not very practical, but it is what you believe, right? Or at least that's what you seem to believe through your writing. And then you kind of had a lot of different concepts that you're bringing into your answers that are showing that you're really engaging with the difficulties that the court was trying to engage with. And so, it's something to think about as you go through this class. And then finally, we just want to think about, so how do we make sense of the ideals, kind of represented by the sunset here, right? The ideals of the Constitution, and maybe that's where you were going, right? That you want the people to be all people, or you want everyone to be protected. And then kind of the harsh reality of, the political environment is like the vast ocean, right? So how do we explain or understand things like the women's rights movement, civil political rights movement, rights movements in general, right, where people are saying, I've got a right? How do we put this into context with the modern political debates? How do we then connect that back to historical debates like the abolition of slavery and the continued practice of slavery? How do we make sense of things like Jim Crow segregation, right? After the 13th, 14th, and the 15th Amendments were supposed to allow Congress to have the power to make all people equal, but that's not what happened, right? Individual states broke off and did their own thing. How do we explain police killings today and over the years of a minority population by a majority population? What does that say about sovereignty? And how do we think about issues like wrongful conviction or plea bargaining or the high cost of incarceration, right? How do we put these practical issues into a conversation where we're balancing interests between social control, but then individual rights and the rights of groups to be treated equally? These are things that we want to think about as we move now from learning how to interpret the Constitution to now applying those interpretations to everyday events.